All right, welcome back, everyone. Today, we're diving into what is arguably the most highly tested and, honestly, the most widely misunderstood area of tort law in this explainer: causation and remoteness. You know, to actually ace your exams, it's not enough to just spot a breach of duty. You've got to prove that the breach actually matters.
So, here's our roadmap for today. We'll be looking at the two massive hurdles of damage: factual causation, breaking the causal chain; legal causation; and finally, foreseeability versus eggshell skulls. Let's get right into it.
Section 1. The two hurdles of damage. Let's quickly review the structural anatomy of a tort.
This is exactly where so many students trip up. Just ask yourself, simply because someone was careless, just because they breached their legal duty to someone else, does the law automatically make them cut a check? Well, the answer, unequivocally, is no.
You already know the first two elements here. You've studied duty of care and you've studied breach. But today, we're putting a massive magnifying glass right on that third bullet point: the absolute complexities of damage caused by the breach. Because look, proving someone acted badly, that's only half the battle, right? You have to prove their bad action actually caused a specific, compensable harm.
Moving on to Section 2, factual causation, but for. This is all about establishing the true physical facts. Did action A actually cause result B?
Which brings us to the famous but-for test. Would the damage have occurred but for the breach of duty? It's literally the absolute baseline rule you need to memorize before we even touch the edge cases. Would the injury have happened but for the negligence? If the answer is yes, meaning, hey, the injury would have happened anyway, then the whole claim fails.
Okay, you absolutely must cite the landmark case of Barnett versus Chelsea and Kensington Hospital on your exams. It's a classic. Picture this. A night watchman shows up at a hospital early in the morning, right? He's suffering from severe nausea. The doctor on duty straight up refuses to examine him. Careless? Yes. A breach of duty? For sure. The doctor just sends him home to see his GP. Well, 5 hours later, the man tragically dies of arsenic poisoning. Turns out he'd been murdered. Now, obviously, the hospital breached its duty here, but apply the but-for test. The medical evidence actually showed that even if the doctor had examined him, it was already way too late. No treatment would have saved him. He would have died anyway. So because of that tragic reality, it fails the but-for test. The hospital is completely off the hook for his death.
All right, Section 3, breaking the causal chain. Barnett is straightforward, just one timeline. But what happens when the real world gets super messy? When you're dealing with multiple possible causes, Wilshire v. Essex Area Health Authority is your go-to case. It's a really tragic one. A premature baby developed a condition that actually had 5 entirely different possible medical causes. And get this, only one of those 5 was the hospital's negligence. In situations like this, the courts ruled that you have to prove the breach was a material cause on a balance of probabilities. You can't just wave your hands and say they increased the risk. No, you have to prove it was the probable cause.
Which brings us to a magic number, 51. That's the absolute threshold in tort law. As we saw in the Hodson case, if a claimant already had, say, a 75% chance of developing a condition regardless of a medical mistake, well, you need at least a 51% chance that the negligence itself caused the damage to win your claim. If you can't hit that 51% mark, you simply can't establish factual causation, period.
But okay, let's pretend you do hit that 51%. Are you safe? Well, not quite. The law loves its Latin, and this right here is where you'll easily lose points if you aren't paying attention. Novus actus interveniens, a new intervening event. But here's the catch. An intervening event only cuts off the defendant's liability if it's considered an entirely separate, completely unforeseeable occurrence. It has to fully overtake that original harm.
This leads to what I like to call the dark humor of tort law. Look at the chain of events in Baker v. Willoughby. First, the defendant negligently injures the claimant's leg in a car crash. Okay, bad enough. But then, sometime later, the claimant is at work and an armed robber shoots him in the exact same already injured leg. No way, right? The damage is so bad the leg requires full amputation. Now, the original driver tried to argue, hey, my liability ended the second he got shot. That robbery is totally a novus actus interveniens. But the House of Lords, they completely disagreed. They ruled that the first defendant's liability for that initial leg injury continues. Why? Because tort law compensates for the inability to lead a full life, and that inability doesn't just magically disappear when a new injury overtakes it.
Moving right along to Section 4, legal causation, or remoteness. You've proven factual cause. Great. Now the court asks, is it actually fair to hold them liable?
This is a massive shift in legal history, and it is a classic absolute must-know contrast for your exams. On one side, back in 1921, we had Remoteness. This established the super unforgiving direct consequence test. Basically, if your negligence caused a tiny spark that somehow burned down a whole ship, guess what? You paid for the whole ship, even if you literally couldn't have predicted it in a million years. But then, modern law stepped in. On the right side, we have Wagon Mountain 01, which established the reasonable foreseeability test. Today, a defendant is only on the hook for the type of damage that a reasonable person could have foreseen at the exact moment they breached their duty. Much more practical, right?
Which brings us to our final section, number 5, foreseeability versus eggshell skulls. How does all this apply to real, fragile humans? And this is the ultimate rule-breaking exception to the foreseeability test, the eggshell skull rule. It's fascinating. Think of remoteness not as a rigid formula, but more as a question of fairness. The rule is simple. You must take your victim as you find them, fragility and all. Let's say a normal person would have just suffered a minor bump on the head from your carelessness. But your specific victim, let's say they have a skull literally as thin as an eggshell and they suffer severe brain damage. You do not get to turn around and say, "Whoa, I didn't foresee their weirdly fragile skull." Nope, you are fully liable for the complete extent of those injuries.
If you're talking eggshell skulls, your definitive landmark case is Smith v. Leach, Brain & Co. In this one, the defendant's negligence caused a very foreseeable but minor burn on a claimant's lip. But, incredibly tragically, the claimant had a pre-existing, dormant, cancerous condition. That minor burn actually triggered the cancer and the man died. Now, was death a foreseeable consequence of a tiny lip burn? Absolutely not. But the type of injury, the burn itself, was foreseeable. And because of the eggshell skull rule, the defendant was held totally liable for the full, tragic extent of the loss.
And bringing this all the way back around to intervening events, remember when I said a novice actus has to be unforeseeable? Well, the flip side is that if the intervening act is highly foreseeable, your chain of liability stays perfectly intact. Take this super old but incredibly relevant case of Scott v. Shepard. A guy tosses a lit squib, basically a firework, right into a crowded market hall. It lands on a stall, the stall owner totally panics, naturally, and tosses it away. It lands on a second stall, that owner tosses it away, and finally, boom, it explodes right in the claimant's face, blinding him. The original guy tried to blame the stall owners, saying they intervened, but the court wasn't having it. They said, look, the absurd panic of throwing away a live firework is a completely foreseeable human reaction to your stupidity, so the chain of causation, completely unbroken.
So, as we wrap up this explainer, I want to leave you with a final, kind of provocative thought to ponder for your exams. When you really step back and look at the 51% rules, the eggshell skulls, the constantly shifting lines of remoteness, does the law of negligence actually compensate based on moral fault? Or is this whole thing just one giant, intricate economic game designed to allocate the financial burden of foreseeable risks in a really chaotic world? Grapple with that in your essays. Apply these landmark cases to your problem questions. If you do that, you're going to do absolutely incredibly. Keep studying hard, and I will catch you in the next explainer.